Hi, everyone. I'm Andy Chen. I'm with Ross Strategic, Senior Associate with Ross Strategic, and welcome to the final webinar in the Intergovernmental Working Group series. This webinar is jointly organized by the National Association of Attorneys General and the National Governors Association, and it's intended as a 101 level description of the regulatory frameworks, including Rickra, CERCLA, and the Atomic Energy Act, that cover cleanup across the nuclear weapons complex. Our speakers today will discuss the relationships between these frameworks and how they interact and in some cases overlap. So just to go over the order of the day, we'll start with some opening remarks from DOE EM. Then we'll have a presentation from several representatives from the state's attorneys general offices. Following that, some remarks from a representative from Yakima Nation. After that, we'll have a moderated panel discussion where I'll post some starting questions that our panelists can respond to and interact around. And then we'll conclude with some audience Q&A before we adjourn for the day. Just a few webinar housekeeping items. I'm sure you're all used to these by now, but first off, this webinar is being recorded and will be posted to the NGA website shortly after we're finished. As participants, you all are muted because it's a webinar. So if you have questions, you can use the chat function or the Q&A function to ask during the presentation any clarifying questions that you have. If there's a quick sort of clarifying question, I'll try and break in at certain points during any of the presentations for that. If it's a more detailed question, we'll hold that until the audience Q&A portion, and I'll just run through the various questions that people have for that. You can see Timothy Schoenhaven from NGA is on the call or on the webinar. So if you have any issues with audio or any technology issues, basically, he is your point person for that. So contact Timothy for any technology troubleshooting. So I think that's all for housekeeping. So without further ado, I'll turn it to Mark Gilbertson for some opening remarks. You probably all are familiar with Mark. He's with DOE EM. He is our Associate Principal Deputy Assistant Secretary for Regulatory and Policy Affairs. Mark, I'll turn it over to you.
Thanks, Andy. So it's great to be with you today. While we aren't in person now, it certainly looks like we're closer to that as we move forward, a lot better off position than we were a year ago. Having spent more than 25 years in the EM operations, I'm well versed in the cleanup process roles of the federal, state, and local tribal governments as we execute the work. You are all an integral part in helping DOE meet its environmental legacy operations. While the pandemic forced many of us to continue work remotely, our regular in-person meetings were replaced by video meetings and facilitated webinars. I hope you were able to participate in some of those, like the ones we had on EM, strategic vision and priorities. We held one on waste dispositions. We had a DOE 435 training session, long-term stewardship discussions, and others. These meetings are an excellent way to share timely information and have open discussions. They've also led to some best practices for community outreach and guiding principles for optimal stakeholder interaction. In many cases, we've seen increased participation and higher frequency of interactions. We remain committed to the protection of human health and safety through the strong nuclear safety protection program. While the DOE has authority over its nuclear safety and radioactive waste management programs, it has shared decision-making responsibility over its environmental protection program. For the Resource Conservation and Recovery Act, Rickra, we use 72 compliance agreements, consent decrees, and other forms of legal arrangements with EPA and your clients, the state environmental agencies. Many of these contain enforceable milestones, and as you know, our ability to modify these agreements has some limitations. We recognize how important sessions like this are to keep these lines of communication open to facilitate our successfully implementing the agreements. The more we understand regulatory frameworks and the various ways federal, state, local, and tribal governments work together to implement them, the more we optimize ongoing cleanup. Actual cleanup is complicated. If we're clear on the interrelationships between the regulatory framework and the roles and responsibilities of the players involved, we'll be more effective with the entire cleanup process. 2020 was certainly an inflection point for EM. As you can see with these sites going on, and while you might have a very good idea of what's going on in your individual states and sites, I wanted to take a couple of minutes to talk about some major accomplishments across the complex. We completed the plutonium fishing demolition at Hanford, plant demolition. We removed all remaining contaminated buildings at East Tennessee Technology Park in Oak Ridge. We removed 11 million tons of debris from Moab in Utah. We're beginning to remove the legacy, and completing soon, removing the legacy buildings from the Energy Technology Engineering Center in California and beginning demolition activities for the pool type reactor at the Lawrence Livermore National Laboratory in California. These are just a couple of examples of the work that we got going on and the good accomplishments for the program overall. And then we have one of the, well, it is the largest cleanup program in the world. You know, for fiscal year 2020, we're focusing on big issues like tank waste cleanup, while allocating sufficient resources for ongoing priorities like soils and groundwater cleanup and D&D of aging infrastructure. Next slide. I wanted to highlight, besides the sites that we've got, which you're probably familiar with, wanted to also kind of make you aware of the disposal sites that we have around the country, because sometimes it's just people aren't aware of it. And it's a big component in the completion of our EM activities. I also would like to highlight a couple of other sites that aren't on this slide that are key places that we utilize to disposition radioactive waste materials. First would be Energy Solutions in Utah, which is a Class A disposal facility that takes low-level and mixed low-level waste. And the second one is Waste Control Specialists, which is a Class A, B, and C disposal site in Texas that takes low-level waste and mixed low-level waste. They're integral to the process. So you can see, besides what EM's got in ongoing cleanup, you know, I'd also kind of call out we in the department work with you at a number of other sites that we've already cleaned up in monitoring the historic cleanups we've done with our LM sites, and that touches many other states across the country. Communication and program transparency are key to program success. EM's working with ECOS and EPA and restarting the cleanup dialogue, which will be another committed platform for EM's partners to inform our priorities and enhance ongoing cleanup. This will optimize information sharing between DOE, EPA, and state leaders. And I think the success that we've had, if you saw the 2022 budget request, and if you're kind of tracking things up on the Hill, the House mark on that budget request was very close to it. So I think you're seeing a lot more alignment between the administration and Congress with regard to trying to achieve our cleanup goals as we move forward. We're paying close attention to the new administration's priorities and how EM fits in the overall goals. This includes important issues like climate, sustainability, environmental justice, racial justice, and workforce diversity and development. In many ways, these issues are at the heart of the EM mission. So it's important that we consider this and other administrations with a fresh new outlook. If we can meet in person this year, I hope you consider participating in the upcoming combined intergovernmental meeting That meeting's been a valuable opportunity for tribal, state, and other intergovernmental partners to gather together and have productive discussions. The virtual format for last year's was a good stopgap, but I know the face-to-face aspect is something that people have been missing. So thanks again for participating today. I will stay on through this webinar and will be available for questions as we go through the process. So whether it's right now a clarifying question or later on when we come to the public comment session, I'm open for that. But I'm going to turn it over to the panel because we got a lot of great, interesting things to talk about, and we've got some very impressive people to deliver the information today. So Andy, back to you.
Great. Thank you, Mark. So we're going to go ahead and start with our state attorneys general. And for that, we're joined by three of our colleagues. Daniel Miller is a senior assistant attorney general with the Natural Resources and Environment section at Colorado Department of Law. Stephen Stout is senior counsel, Office of the General Counsel for Tennessee Department of Environment and Conservation. And Caroline Kress is our Assistant Attorney General from the Washington State Office of the Attorney General, and they have a brief presentation for us. So I will turn it over to them.
Thanks, Andy. And this is Dan Miller. And thanks to Caroline Kress for this colorful slide we're looking at here that looks a little busy at first, but it's a really good graphical presentation of how the four different sets of statutory regimes interact for cleanups at DOE sites. So in the red, that's the Atomic Energy Act that governs source, special nuclear, and byproduct materials. The blue is Rickra. Rickra regulates hazardous waste from cradle to grave, as they say. So the management of hazardous waste to keep it from becoming an environmental problem. And it also regulates cleanup of hazardous waste when it has not been managed properly. The yellow, slightly oval shape, that's state hazardous waste laws, which states have to regulate all the wastes that are regulated under the federal RCRA in order to maintain state authorization from EPA, and they can regulate other wastes as well. One example, some states are starting to regulate some of the PFAS chemicals, which EPA has not yet addressed under RCRA. And then in green is CERCLA, Superfund, and it deals with the cleanup of hazardous substances that are released to the environment. So under the AEA, RCRA, and CERCLA, they all regulate different sets of things, but those sets overlap. So sometimes AEA materials are contained in a waste stream that also contains hazardous wastes, and that's what mixed wastes are. And so if a mixed waste has been released into the environment, it can also be regulated by CERCLA as well as RCRA and the Atomic Energy Act. If you have a waste that is a hazardous waste, but doesn't have the radioactive component and it's been released into the environment, then you have that the lower overlapping, not quite sure what shape to call that, but where CERCLA and RCRA overlap, both those statutes can apply. And if you have strictly radionuclides that are released into the environment, CERCLA and the AEA can cover those, but RCRA does not. RCRA excludes the AEA materials. Next slide. So we're here talking about states and DOE facilities, and one question people might have is, can states even regulate the federal government? And the answer to that question is yes. Of course, under our Constitution, the federal government is the supreme authority. And when the Constitution was drafted, it incorporated a lot of concepts from English common law, and one of those was the concept of sovereign immunity, and that's kind of enshrined in the Supremacy Clause. Sovereign immunity basically means the king or the sovereign government can do no wrong. So you can't, under our Constitution, you can't sue the federal government unless the federal government says you can. And if you're a state, you can't regulate them unless the federal government says you can. And the government has done that by passing statutes that contain what are called waivers of sovereign immunity. All the major environmental laws contain those waivers. So Congress has tried to give states authority over federal facilities. Federal courts have consistently interpreted the waivers very narrowly. Hancock versus Train is a case involving the Clean Air Act at a DOE facility and some other federal sites. Back in the early 70s, the Clean Air Act waiver is quoted there, said that federal agencies had to comply with state requirements respecting control and abatement of air pollution to the same extent that any person is subject to such requirements. Well, under Kentucky's law, a private person would have to get a permit for certain air pollution creating activities. And the Department of Energy and other agencies challenged the application or the requirement to get a permit. And that went up to the Supreme Court, and the Supreme Court said, nope, federal agencies don't have to get a permit from the state, even though that was the only way to implement the requirements of the Clean Air Act. Congress came back within a year or so and amended the Clean Air Act to clarify that federal agencies do have to get permits. There was a companion decision to the Hancock case dealing with the Clean Water Act. Congress also, and again, the Supreme Court ruled states couldn't require federal agencies to get permits. Again, Congress came back and overrode that decision and clarified that federal agencies do have to get Clean Water Act permits. There was another case that went up to the Supreme Court over penalties against federal agencies under the Clean Water Act and Rickra. That case, again, Supreme Court held that states couldn't penalize federal agencies under those laws. Congress overturned that with respect to Rickra. So the current state of things is states can require federal agencies to get permits under all those acts there listed, and they can also fine federal agencies for violations of state hazardous waste laws. Next slide. Okay, so I'm just going to give a quick overview of CERCLA. CERCLA has two main components. One is the cleanup part, the remediation of hazardous substances that have been released to the environment or where there's a threat of release. And it has the natural resource damage provisions. Natural resource damages are money damages that trustees can get by suing people who are responsible for the release of hazardous substances to the environment where that release injures a trust resource. So first, let's talk about cleanup. Generally, under Superfund, EPA is the decision maker at non-federal sites. States can partner with EPA, but unlike the Clean Air Act, Clean Water Act, and Rickra, CERCLA is predominantly a federal statute. States are not really the decision makers under CERCLA. They do have a role in cooperating with EPA on cleanups. They have to pay for certain portion of cleanups where the cleanup has been paid for under the Superfund Act or the Superfund itself. And they can identify state standards that cleanup should meet, but they are not the cleanup decision makers under CERCLA. At federal sites, EPA is not the primary regulator. CERCLA granted a lot of different authorities to the president in the statute, and President Reagan issued an executive order delegating his authorities to different agencies. Among the authorities he delegated were to the Department of Energy and Department of Defense. They have the authority to make cleanup decisions at facilities under their jurisdiction, so they can take removal actions and they can take remedial actions. Congress amended Superfund in 1986 to add various sections, including Section 120. Section 120 relates to federal facilities. It's partly intended to expedite the cleanup of federal facilities that were listed on the NPL. And that section requires EPA to concur in any remedy that is selected for a federal facility on the NPL. So there's quite a few on the NPL. At one point, there were over 140 Department of Defense facilities listed on the NPL, the National Priorities List of the most contaminated sites. And I believe there were at one time 17 DOE facilities. I may have that number off by 1 or 2, but I believe there were 17. That's kind of a quick rundown of the cleanup side. On the natural resource damages slide, I'm sorry. We just updated this slide today to add the NRD provisions, and I realized I forgot a very important player under NRD, and that is the tribes. The tribes don't really have a particular role on the cleanup side, but they can be a trustee for natural resources under their jurisdiction, so they can bring lawsuits for money damages. And the purpose of the damages, whether sought by a tribe or a state or a federal agency, is to try to restore the injured resources. So it's not about protecting human health or the environment, it's about trying to restore the environment to the condition, ideally, that it was in prior to the release. So on the chart here, we'll add another column for tribes indicating that they are natural resource trustees. Federal agencies are trustees for federal resources under their jurisdiction, and states are trustees for state resources under their jurisdiction. What kind of resources are we talking about? It's primarily groundwater, surface water, biota, and wildlife. And you can go to the next slide.
All right, thanks, Dan. So the next overview slide we've got is on the Atomic Energy Act. So as you probably already know, this is the Atomic Energy Act in 1954 was enacted when there was the Atomic Energy Commission at the time, which is the predecessor to DOE and NRC. And it set up a program to manage what we refer to as AEA materials, which is source material, special nuclear material, and byproduct material. Then in 1974, the Energy Reorganization Act split the AEC into basically two streams of regulatory authority, one with DOE and one with the Nuclear Regulatory Commission. So under that framework, at Energy's cleanup sites, it is self-regulating under the Atomic Energy Act, except for a couple of pretty narrow carve-outs where NRC retains jurisdiction. One of those carve-outs is for where an energy facility that's authorized for the express purpose of subsequent long-term storage of high-level radioactive waste. And that's been interpreted by the courts to also include disposal of high-level radioactive waste. So that's why NRC would be licensing the Yucca Mountain facility or whichever facility is selected as a deep geologic facility, deep geologic repository, excuse me. At non-energy sites, NRC is the primary regulator under the Atomic Energy Act, although it can enter into agreements with states to assume that regulatory role over those facilities. And like I said, it does retain this narrow jurisdiction over certain activities at energy sites. And I think that's part of the reason that they are involved in a consultative role in like the 435.1 WEIR process. Then we've got Rickra, which, as Dan said, is really a cradle-to-cradle hazardous waste management system. So it's mostly designed as a preventative program to manage waste properly so that it is not released to the environment, but it also has a component that we call corrective action for releases from any solid waste management unit to the environment. And so in terms of the proactive hazardous waste management part, that applies to everything from generation of the waste, having to designate it, and then governing its storage, treatment, and ultimate disposal. Whereas the corrective action applies to any past releases of hazardous waste at the facility. Under the Rickra, much like the states don't have any decision-making authority under the AEA, Energy doesn't have any decision-making authority under Rickra. It's solely the regulated entity here. So that it makes it a little bit different from both the AEA and CERCLA in that respect. EPA is the primary regulator where states don't have authorized programs, but the Rickra statute does allow for states to pass laws and get authorization from EPA to implement their state laws governing hazardous waste management in lieu of Rickra. So they just have to be as stringent as the federal Rickra laws. And in that case, then the state is the primary regulator and EPA oversees that implementation and can overfile in limited circumstances. And in this case, the NRC does not have any formal regulatory role. I will note also Rickra has a citizen suit, as does CERCLA. The states don't typically have to use citizen suits for enforcement because we have other direct enforcement and permitting mechanisms to do that. But in certain instances, the states can also bring citizen suits. One example would be, I think it was 2015 when the state of Washington, as the state, instead of representing the Department of Ecology, brought a citizen suit against Energy for vapors that were being released from the tanks and exposing workers. So I think that's pretty rare, but I have seen it. And then in terms of corrective action under Rifra, I know at least in Washington, we use our state cleanup law, which is called the Model Toxics Control Act, or MOTCA, to operate as our corrective action program under Rifra. So our state regulations for corrective action point to the MOTCA process and criteria, and we also use the cleanup levels that have been established under that state cleanup law as clean closure levels. So if you're clean closing a tank, for example, you have to remove or decontaminate all the contaminated soils to meet those clean closure cleanup levels. So now we're going to get into kind of how each of these statutes overlaps or interacts with one another. So I'm going to start out with the overlap between RCRA and the AEA. So this is just a little snapshot of the larger diagram we had earlier. And as Dan mentioned, the main overlap here is where we have one waste form that contains both AEA materials and hazardous waste. And so that's called mixed waste. And the states have authority over, if they have authorized programs, they have authority over the hazardous waste component of it, and Energy retains authority over the AEA material portion of it. So one of the reasons that they don't completely overlap is because RCRA applies to hazardous waste, which itself is a subset of solid waste. And RCRA's definition of solid waste expressly excludes source, special nuclear, and byproduct material. However, as I mentioned, mixed waste contains both, and there were some rulemakings in the 80s from both EPA and Energy that ultimately decided that yes, if a single waste form contains both hazardous and radioactive components, it is subject to RCRA to the extent that RCRA applies to the hazardous component of it. And then in 1992, the Federal Facility Compliance Act amended RCRA. This is where the sovereign immunity waiver comes in that Dan was talking about. So it does require Energy and all other federal agencies to comply with all federal and state requirements that relate to hazardous waste management in the same manner and to the same extent as any person is subject to such requirements. And then another aspect of the Federal Facility Compliance Act was it established a requirement for Energy to have site treatment plans at each of its cleanup sites that have schedules for when it's going to treat all of its mixed waste to meet RCRA LDR standards. And so under the RCRA Land Disposal Restriction Program, any waste that are subject to LDR standards must be treated to those standards before disposal, or you can get a treatability variance in some certain circumstances. And in general, as applied to most persons that Rickra applies to, there is also a storage prohibition where you can't store these mixed wastes just indefinitely in lieu of treating them. It's basically a forcing mechanism to push towards developing treatment capacity where it doesn't yet exist. So this rule it was delayed for 3 years to allow the development of these site treatment plans, which essentially provide a safe harbor from the storage prohibition, where if you have an enforceable schedule for getting to the place where you're treating these wastes to meet LDR standards, then you're not going to be violating the storage prohibition. And so 2 examples of this is the Hanford Tri-Party Agreement has requirements requiring an LDR report to be submitted. I think it's every 5 years, a full LDR report, and then in the interim years, kind of a scaled back report, but it's supposed to identify all of the waste streams at Hanford and identify which treatment standards apply to those, and identify, whether that treatment capacity is available or not, and if it's not, has to have enforceable dates to get to that treatment capacity. And then I will let Steve talk about the Oak Ridge Reservation Site Treatment Plan.
Caroline, I think you covered it. The tri-party agreement was in effect a little bit before the passage of the 1992 Federal Facilities Compliance Act. I would say that, as Dan was alluding to, the courts interpreting some of the sovereign immunity waivers and the breadth of those waivers, the Federal Facilities Compliance Act of 1992 was a reversal of a Supreme Court decision, I think the year before, involving the state of Ohio. And there was an argument about the scope of the sovereign immunity waivers in the Clean Water Act and under Rickra. And so this earlier history about EPA developing their approach to mixed waste, sort of led up to this problem. And, by 1992, there was a problem that needed to be fixed with the sovereign immunity waiver, but there was also realization that at DOE facilities like on the Oak Ridge Reservation, there were a lot of things that were subject to land disposal restrictions, but because it was mixed waste and the radioactive component complicated the treatment of the hazardous waste component, there either needed to be technology developed, or if the technology was there, there needed to be treatment capacity developed. And as Caroline says, the site treatment plan provides a safe harbor and a schedule to get the facilities in compliance, because at least at Oak Ridge, and I think all across the DOE complex, there was a lot of mixed waste, and we had to figure out what to do with it. And it's been pretty successful. So I'll turn it back over to Caroline.
Thanks, Steve. And that's a good point about the tri-party agreement, since that wasn't agreed to before the Federal Facility Compliance Act went into effect. There was a provision in the Federal Facility Compliance Act that if you already had an agreement that essentially satisfied that requirement to have this enforceable schedule to get the mixed waste treated to LDR standards, that could be used instead. So that's how we use the TPA at Hanford to serve as a site treatment plan. So in addition to this, the definitional exclusion of AAA materials from Rickra's definition of solid waste, there's also kind of an overarching issue of preemption. And so the AEA has a specific provision that has actually been called by the U.S. Supreme Court a non-preemption clause, because it basically says that nothing in the AEA can prohibit states from regulating these materials for purposes other than protection against radiation hazards. So it basically leaves the door open to state or local regulation of AEA materials for valid reasons that don't directly relate to the radiation hazard. So one example was for the Virginia uranium case at the Supreme Court, where a Virginia law governed essentially the mining of, uranium milling. And actually, I'm forgetting some of the detail of that case, so I'm not going to go into it in depth because I don't want to say anything inaccurate right now. So basically, the bottom line of that case is that if the state has a legitimate reason to regulate a certain material for a reason other than to protect against radiation hazards, that is not preempted as a matter of federal law supremacy. And then there's one other provision that governs this overlap between Rickra and AEA, and that's what we call the inconsistency provision. This also applies to things like the Clean Water Act, but we're going to focus here on how it relates to the AEA. So Rickra says that you can't construe anything in Rifra to apply to essentially AEA materials except to the extent that such application or regulation is not inconsistent with the requirements of such acts. So this provision has been interpreted by the courts. This first case, the Legal Environmental Assistance Foundation case, actually came out of Oak Ridge back in the 80s. And that case held that in order to find that there is this inconsistency where these other laws could trump Rickra, you have to find that specific provisions of the two statutes are in irreconcilable conflict with each other. So it has to be that like a provision of Rickra would force you to violate the AEA. One example is if Rickra were to force you to release national security information that the AEA prohibits disclosure of, that would be an irreconcilable conflict. And they have said that energy has the burden of proof to demonstrate this inconsistency would result. So that involves essentially identifying which specific provisions of each of the statutes are at issue and how they directly conflict, and basically how one makes it impossible to comply with the other. And I will turn it over to Steve for jurisdictional overlap of CERCLA and AEA.
Okay, thanks, Caroline. This Venn diagram, Caroline did the Venn diagrams, and I knew this was complicated, but I especially realized how complicated it was when I saw the first Venn diagram with all the circles. But dealing with these overlap areas is what we do. And next slide, please. I'm going to tell a story that happened at Oak Ridge, and I actually said, don't give me as many slides because I'll probably take a long time on this slide, and I know it's got a lot of information on it, but in the about the last 5 years, I spent a lot of time on this issue of how CERCLA and the Atomic Energy Act interact, and we've talked about a lot of the major environmental statutes, and the major environmental statutes have one thing in common, and that includes CERCLA. They're administered by EPA. Most of them, as Dan said, are administered by the states because it's a federal statute, but the states have a very large role. Clean Water Act in particular, Clean Air Act. The states do a lot of the actual work to implement these statutes. CERCLA, the state has a role, but EPA, it's an EPA statute. It's not delegated or authorized to the state. Now, the Atomic Energy Act is an outlier in the sense that EPA has nothing to do with the Atomic Energy Act. It applies, as Caroline said, for DOE to self-regulate or the Nuclear Regulatory Commission. And, there's a very little bit of overlap between what the Nuclear Regulatory Commission does in licensing and the activities that DOE has. So for the most part, DOE regulates itself under the Atomic Energy Act and is basically occupies the field of radionuclides. However, CERCLA governs cleanups, and we talked about it interacts to some extent with the Rickra Corrective Action Program. So CERCLA deals with cleanups, and they deal with cleanups through using something called applicable, relevant, and appropriate requirements, or ARRs, which is on the slide. And they borrow the substantive requirements from the other major statutes that could be used to deal with the cleanup situation. And so this was, I would look at it that this was in the arena of CERCLA, but what it was really dealing with was the Atomic Energy Act versus the Clean Water Act. And I'll tell you why. The larger context for this formal dispute, which under our federal facilities agreement, we have a dispute resolution provision that goes up through several levels among the parties. The state signed the federal facilities agreement in Oak Ridge, of course, the Department of Energy and the EPA. And there are different levels going up the chain of management of the agency, with the EPA administrator on top of the pyramid to make a final decision if need be. And so the argument was the Atomic Energy Act, well, let me get back to the main context. It was about a landfill overall, but more specifically, it was about how to address the discharges of wastewater from a landfill, and particularly with radionuclides being a big part of it. And so the Atomic Energy Act has one set of discharge limits, and CERCLA approaches the situation differently. And so there was this competition between the Clean Water Act and the Atomic Energy Act, and also you see on the top of the slide this concept of the CERCLA risk range. And the CERCLA risk range is for carcinogens. The cleanups, you try to keep the cleanups in standards of protectiveness between 1 in a million chance, 1 in a million chance of excess cancer over a lifetime, and 1 in 10,000. So it's 1 to the 10 to the minus 4, 1 to the 10 to the minus 6. So that's the range. And the way that the Atomic Energy Act regulates is they speak in terms of dosage. And the way CERCLA regulates, they speak in terms of risk, and there needs to be a translation. But when we started looking at which requirements would apply, some of the Atomic Energy Act requirements did, and some of them didn't. And the litmus test was whether or not these fall within the CERCLA risk range. And then the second part of this dispute, the part about the Clean Water Act, was there was a 1976 Supreme Court decision that set a boundary between the Atomic Energy Act and the Clean Water Act, just if the Clean Water Act and the Atomic Energy Act are the only two things being considered. And the Clean Water Act definition of pollutant excludes the Atomic Energy Act source, byproduct, special nuclear materials, like we talked about before, in the definition of hazardous waste. It's the same type of approach. But under the term ARRR, it's applicable requirements. So the issue was, we knew that the Clean Water Act wasn't applicable, but since we're talking about things being discharged into water, even though they're radionuclides, the way that the Clean Water Act deals with things that are being discharged into water could be relevant and appropriate. And so at the end of the day, after this dispute wound its way up to Washington, D.C., after many years, the decision came down, and we got a sort of a mixed bag. But some of the Clean Water Act was applied, or was recognized that it could be applied as ARRRs to govern this cleanup. Some of the Atomic Energy Act, specifically some provisions that dealt with low-level radioactive waste landfills, they were recognized. And some of the parts of the Clean Water Act that are sort of integral to the whole, they were not recognized. And at the end of the day, we started the dispute with an argument about different assumptions to make to calculate a site-specific risk level for this particular creek in Tennessee, in Oak Ridge. And we're back to that point. after all this dispute, we have some guidance, but we're now trying to implement the decision and apply the site-specific flexibility that was in the administrator's decision. So it gets complicated, it goes through a convoluted path, and we wound back up in pretty much the same place. But we know now that the Clean Water Act, at least for this particular decision, does have some bearing on how you handle radionuclides in a CERCLA cleanup.
So I'm going to talk about the jurisdictional overlap between Rickra and CERCLA, and this is a portion of the Venn diagram we saw before. If hazardous wastes have been released into the environment, they're subject to corrective action under Rickra, and they're also subject to remedial action under CERCLA. And pretty much any waste that is a hazardous waste under Rickra is a hazardous substance under CERCLA. There are some CERCLA hazardous substances that are not also hazardous wastes. So there's a lot of potential for overlap between them. Both statutes can apply in a lot of circumstances. Typically, they are only both applied at federal facilities, and that's largely because EPA has policy, a deferral policy for private sites, where if a site cleanup can be managed under Rickra or a state Rickra program, EPA will defer to that program rather than bringing the cleanup under CERCLA. But that policy doesn't apply to Superfund site or to federal sites. And so we're left with a situation where states are generally the cleanup decision makers under Rickra, because I think it's like 47 or 48 of the 50 states have been authorized to implement state hazardous waste programs in lieu of the EPA program. So states are the hazardous waste decision makers, but at federal facilities, particularly DOE facilities and DOD facilities, those two agencies are the cleanup decision makers under CERCLA for sites under their jurisdiction. And that's tweaked a little bit for DOE and DOD sites that are listed on the national priorities list. Those sites, EPA has to concur in any remedy selected for a DOD or DOE site on the NPL. So what happens when both these laws apply and you have a state making one cleanup decision and a federal agency making a different one? We actually had a big argument about that in Colorado, and it was at a rocky site, but not at Rocky Flats, where we've been able to work pretty well with DOE over the years. It was at the Rocky Mountain Arsenal, which was a site where the Army produced chemical weapons for decades. And then when they stopped chemical weapons production, they leased a large part of that facility to Shell oil company to make pesticides. And the Arsenal was quite a contaminated site. At one point, one court described a surface impoundment there called Basin F as the most contaminated square mile on Earth. So we didn't have a very cooperative relationship with the Army at the Arsenal, and there was a lot of litigation over it. At one point, Colorado was trying to enforce a closure plan for Basin F, and the Army didn't want to comply with that. And there was a lawsuit that made it all the way up to the 10th Circuit. And I haven't gone into detail here. We will be providing some, like an appendix, I guess, of relevant materials after the webinar, if you want to dive into the details. But the Army had made a bunch of arguments relying on various provisions in CERCLA as to why CERCLA should trump over Rickra. And the bottom line is that the 10th Circuit rejected all those arguments. They rejected the argument that the CERCLA's ARARS provision, where CERCLA borrows cleanup standards from other environmental laws, including state environmental laws. The Army had argued that was the sole way for states to get involved in CERCLA cleanups. The court rejected that. CERCLA actually has a couple of what you might call non-preemption provisions in it. The court relied on those a fair amount. It also noted a provision in CERCLA, that CERCLA section 120, that refers to, that's the federal facility section. And that section says that nothing in CERCLA impairs a federal agency's obligation to comply with Rickra corrective action requirements. So the 10th Circuit is the only circuit where there's been a court decision that talks about how Rickra and CERCLA apply, and the outcome in that case was they both apply. So it's not binding in other jurisdictions, but it's certainly a plausible outcome. And now we're going to talk about Rickra permits at CERCLA sites.
Yeah, so this is something about Rickra CERCLA overlap that comes up quite often, which is the CERCLA permit exemption. So this is section 121E1 of CERCLA. And it basically says that if you're conducting a CERCLA action entirely on site, you don't need to get an environmental permit for that CERCLA action. This has been interpreted kind of all across the board by different parties, but EPA has said in memos that its belief is that CERCLA permit exemption does not apply to pre-existing Rickra units, and I'm realizing that there's a typo here on that slide, at CERCLA sites. So if you have a site where there is a pre-existing requirement to have a Rickra permit, if you had a treatment, storage, or disposal unit as of the effective date of Rickra at that site, then a CERCLA action coming later on and overlapping it does not extinguish that pre-existing Rickra requirement. It only applies, it only exempts the requirement to have a permit for the actual actions that are being taken under CERCLA. And even when the permit waiver does kick in and you don't need a permit for your CERCLA action, that action must still meet the substantive requirements of what you would be requiring in the permit. And that's where ARARs come in. And the permit exemption has also been interpreted by a few different courts. The first one was a question about basically whether all of Hanford was on site for CERCLA purposes. And that decision said that no, the term on site is not boundless. You actually have to identify the extent of contamination and suitable areas in very close proximity to that contamination. So where Hanford is this sprawling site with a lot of patches of contamination all around it, each one of those patches is itself its own on-site area, not the entire facility. And in a follow-up case to the case that I believe Dan was just talking about, coming out of the Rocky Mountain Arsenal, similar decision there that the permit waiver doesn't preempt a pre-existing requirement to get a Rickra permit or post-closure plan in place. We also had a decision out of the Pollution Control Hearings Board here in Washington a few years ago that dealt, instead of with the permit exemption itself, the permit exemption was claimed in that case to bar the state's authority to require compliance with Rickra's generator requirements, which are not subject to permitting. They apply to anyone who generates a dangerous waste in Washington. And so the board in that case did hold that that the permit exemption does not exempt you from all requirements related to Rickra, or in this case, the Hazardous Waste Management Act. And even when it does apply, it only applies during the remedial action that's being done under CERCLA. So in that case, a CERCLA action was planned for this facility, but no investigation had taken place, no decision documents were in place yet. And so even if it was a permitting question, that exemption would not have kicked in at that time. And then here we're moving now into kind of how do we actually on the ground manage these jurisdictional overlaps and sometimes conflicts between the regulatory authorities. And The main way we do it is through various site agreements. So I know at Hanford, we have the tri-party agreement, which serves as both a consent order under Rickra and a federal facility agreement under CERCLA. We also have a consent decree that was entered by a federal district court that governs kind of the near-term milestones for the tank waste treatment mission at Hanford, which is retrieving waste from some of the single shell tanks and getting the waste treatment plant up and running. And I will kick it to Dan and Steve to talk about their site agreements as well.
Yes, thank you. So, Oak Ridge has a site treatment plan for mixed waste, which we talked about. We have a federal facilities agreement where we agree to coordinate our Rickra Corrective Action program, as we are an authorized state in Tennessee, with CERCLA, and make decisions to try to reconcile those two authorities. And then we were wondering about how to interpret the term oversight, which is one of the questions. So we spent most of the time answering how these statutes interact or don't interact with one another, which I think was the top question. And then we talk about oversight. Now, most of the time we use oversight in terms of regulatory enforcement. But sometimes in this particular case in Oak Ridge, there is an oversight over activities that are being purely conducted under the Atomic Energy Act. And they're not being done under CERCLA for cleanup. They don't even involve waste. And there is an area in which a grant is made to a site like Oak Ridge, and there is some money provided for some independent sampling and monitoring of DOE's compliance with its self-regulating role under the Atomic Energy Act. And that's called an agreement in principle. And that is a fraction of what our Oak Ridge office does, but it is some of what our Oak Ridge office does in a non-regulatory role, but in a role as an expert providing independent oversight to DOE.
I think we can go to the next slide. So I talked a little bit earlier about the fractious relationship, I guess you could say, that Colorado had with the Army at the Rocky Mountain Arsenal. And while it wasn't always smooth sailing across town at Rocky Flats between Colorado and DOE, we did manage to avoid litigation about cleanup and instead cleaned up the site under some negotiated agreements. I'm mostly going to talk about the Rocky Flats cleanup agreement, but in fact, there have been 4 separate negotiated agreements related to the investigation, remediation, and monitoring of environmental contamination at Rocky Flats. The very first one was in 1986. It was a compliance order on consent with, I think, EPA, Colorado, and DOE that was kind of focused on trying to get DOE to identify its permitting and waste streams under Rickra. That was replaced in 1991 with a CERCLA interagency agreement that was combined with the Rickra Corrective Action Order. That agreement divided the site into, I think it was 16 operable units. And it was kind of the standard CERCLA approach to cleaning up the site, very process heavy, a lot of documents. Everything was remedial investigation and feasibility study for the investigation side, and then a ROD, and it was super slow. It was partly because of all the security requirements that were attendant to having an operating nuclear weapons facility, and partly just because the remedial process under CERCLA is kind of slow. The Rocky Flats cleanup agreement was negotiated over a period of a couple of years after we'd had a couple of years experience under the 1991 interagency agreement, and DOE was very far behind on a lot of the schedules, The site had been closed as far as production happening, and they got a new contractor in there with a performance-based contract instead of an M&O-based contract, and all these things kind of came together. I think that agreement was part of the reason for the success that we talk about here on the slide, where the cleanup of the Rocky Flats was completed ahead of schedule and under budget. Certainly wasn't the only reason, but we designed this agreement to try to streamline as much as possible the investigation and cleanup of the site. So instead of having 16 operable units, we had 2. We were doing it under both CERCLA and Rickra, and we also accommodated the Atomic Energy Act and even the Defense Nuclear Facilities Safety Board into things. But we tried to minimize the amount of duplicative regulatory oversight. So we designated the state as the lead regulatory agency for the industrial area, the area of the facility where all the buildings were. And EPA was the lead regulatory agency for the buffer zone. That phrase, lead regulatory agency, is different from lead agency under CERCLA. Here it really means the regulator who does most of the work and is kind of in charge of that part of the cleanup. The parties agreed up front to kind of a vision for some cleanup endpoints and to an action level framework. The action level framework is it's not cleanup standards exactly, but they were standards that would trigger a response action, like a removal action. So while we were in the industrial area, the state was regulating cleanup pursuant to state law. But as we discussed earlier, state law, hazardous waste law, doesn't cover radionuclides. So we negotiated provisions in the agreement where the state would carry out CERCLA authority as needed to address any plutonium or other radionuclides. Of course, the state doesn't have final decision-making authority under CERCLA. So if there were a dispute between a cleanup decision that the state made and something DOE wanted, that would ultimately go up a dispute resolution process where I believe at the end of the day, the EPA administrator made the final call. Things were flipped in the buffer zone where EPA regulated cleanup under CERCLA, and the state was the support agency. So the idea of the lead regulatory agency and support regulatory agency was the support agency would go along with the lead agency's decision unless that decision was in conflict with its own statutory authorities. So like if we were the lead in the industrial area, we made a cleanup decision, maybe EPA didn't totally agree with it, but if it wasn't wrong under CERCLA, they would concur in it. And similarly in the buffer zone, if EPA made a cleanup decision, might not have been what we would have decided, but if it wasn't wrong under the Colorado Hazardous Waste Act, we'd concur in it. So we did all those things. We did almost all of the actual cleanup was done under some sort of accelerated action, which made use of CERCLA's removal authorities and Rickra's interim measure authority. At the end of the day, we looked at the whole site. We did a comprehensive risk assessment, decided if we needed to take any more cleanup actions. And for the industrial area, we decided that we needed to do institutional controls. And for the buffer zone, we decided that it had been remediated to basically unrestricted use levels. So we were able to ultimately delist wasn't exactly the buffer zone. We can reconfigure the OUs a little bit geographically, but that area was completely delisted from the MPL. The informal industrial area is still listed on the MPL. The buffer zone is now part of the Rocky Flats National Wildlife Refuge, and it is suitable for unlimited unrestricted use and unlimited exposure. So the process, the only other thing I'll say about it, the process was that it was extremely consultative, a lot of work up front instead of DOE going off and, on its own or with its contractor coming up with a proposal, spending a lot of time writing it, putting it to paper, and then submitting it for review by the state or EPA. The agencies largely work together. And we also had lots and lots and lots of public involvement. So end result, it was, as I said, ahead of schedule, under budget. And now we're under our fourth cleanup agreement, which again is a joint CERCLA interagency agreement, Rickra corrective action order. State is the lead regulatory agency for the whole site now. EPA is a support agency. DOE is conducting, ongoing operation, maintenance, and management under that agreement. And that's all I have on that slide.
All right, and then real quick, the last thing we have here is one of the ways in which Hanford has tried to accommodate this jurisdictional overlap, and specifically CERCLA and Rifra. So a couple of years ago, after a few years of negotiations, we amended the tri-party agreement. It had already contemplated the possibility of basically coordinating Rickra closures with CERCLA cleanups, but the way it was written didn't really make it functional. It didn't say how you actually go about coordinating them, what are the mechanics of that. And so we updated the tri-party agreement a couple of years ago to make those mechanics more clear. So that involved amendments to part of the action plan, as well as a series of new TPA milestones that are tied to existing milestones for CERCLA and Rickra corrective action investigation and remedial decisions. So we basically established this other set of milestones that requires submission of Rickra closure plan information at the time that that information becomes available through the CERCLA investigation process. And to make that operational under our permitting regulations, we use a provision in our regulations that essentially allows ecology to make a case-by-case determination that certain permit application material can't be provided at the time. Because otherwise, not having closure plans in place for all of these TSC units would result in an incomplete application that would have to be denied. But we've worked this framework up so that we can get around that and basically defer the submission of some of these closure plans until CERCLA essentially catches up with it. I think one wrinkle to this now, we haven't actually implemented any of these yet. They're all set out in the future. But we've recently heard that a lot of the CERCLA milestones are being delayed for budget reasons. So we kind of have yet to figure out how that impacts the closure plans that are tied to them. But that's how we have started trying to address it at Hanford. And that is all that we have for now.
Great, thanks everyone. That was really helpful, very informative. I wanted to throw it real quickly to Tom Zillman, who is a tribal attorney for Yakima Nation. Tom's gonna talk a little bit about what he's seeing from the Yakima side of things. Tom?
Thanks, Andy, and good afternoon, everybody. The way that Indian tribes interact with DOE and EPA and the states at nuclear weapons legacy sites, it mostly involves CERCLA, which we've talked about in this webinar. Not so much the other statutes, so I'll mainly focus on the role that tribes have under CERCLA. Tribes do have a pretty major role in the response side of cleanups, as well as the natural resource damages, which Dan mentioned earlier. And it is true that even outside of their reservations, tribes are considered trustees for natural resources, mainly because of off-reservation treaty rights that they have to fish to hunt and gather foods and medicines on Aboriginal lands. In our case, it's the Hanford site. The Yakama Nation has not only treaty reserved rights in that area, but also has historic areas where villages were along the Columbia River. So there are historic resources that are also at stake at the Hanford site. But I want to mention at least one legal mechanism that tribes can use to act as essentially a regulator or an independent attorney general, shall we say. And that's one of the things that Caroline mentioned earlier. It's the citizen suit provisions of these statutes. Both Rickra and CERCLA have provisions that allow citizens to file actions and the way that the statutes are worded, both of them are fairly similar, against any person, including the United States, who is alleged to be in violation of any standard, regulation, condition, requirement, or order which has become effective pursuant to this chapter. And so that includes, as it says in the statute, federal facility agreements. So the way that the statutes define citizen does not include Indian tribes as sovereign governments, but individual enrolled members of Indian tribes, certainly as citizens of the United States, can file actions in federal court. Federal courts have jurisdictions over these actions to enforce the standards of things like ARARs, federal facility agreement requirements. I'd like to mention a little later, I don't have a whole lot of time, but the National Historic Preservation Act is one of the ARARs that Indian tribes are interested in enforcing. So citizen suits can be used by individual tribal members. We had a tribal member at the Yakama Nation called, his name was Louis Cloud. He was a tribal elder, tribal council member, and he did file a claim as part of a separate lawsuit to try and enforce risk assessments at Hanford about 15 years ago. He filed a citizen suit on his own behalf. And that was dismissed as part of a settlement. But the Yakama Nation has also filed notices of intent. Now, in order to invoke a citizen suit provision of either Rickra or CERCLA, you do have to file a 60-day notice of intent. And so we have filed a 60-day notice of intent for the 300 area of the Hanford site and are working to settle issues at the 300 area regarding that record of decision about 8 years ago with the Department of Energy. Now, one of the things I want to mention is for federal facilities, the jurisdictional bar that usually applies to other cleanup sites, non-federal cleanup sites, that says, or courts have ruled that you cannot file a citizen suit until the cleanup is complete. That does not apply to Section 120 cleanups, which is what the federal facilities are. And so in the Ninth Circuit, at least, within the Ninth Circuit, under what's called the Fort Ord Toxics Project case in California, the court ruled that the exception for Section 120 cleanups applies to the jurisdictional bar in the statute that says you have to wait till the cleanups are done. So if an enrolled tribal member of an Indian tribe that has an interest in a site wants to file a claim to enforce any standards in the statute or the federal facility agreements, they don't have to wait until the cleanup's done. They can. It's advisable probably to wait until the record of decision is completed so that you have an administrative record to go on, but they don't have to wait till the cleanup's done. So that's a very important qualification within the Ninth Circuit. Now, the interests that and the standards that the Yakama Nation and other Indian tribes want to at least enforce in those types of cases involve, of course, the impacts of the cleanups and the contaminants and the radionuclides on the uses that the tribal members in the both presently and in the future will have at those sites. I mentioned earlier treaty rights that the tribal governments hold in trust for their enrolled members. And we have looked to DOE and EPA to enforce what we would call a tribal use standard for risk assessments. So when they are doing the RIFS process, their remedial investigation and feasibility studies, it's very important for the regulators and DOE to work together to enforce what we would call a treaty standard of cleanup, largely of unrestricted use, to try and make sure that the human health standards for treaty uses is protected. And that includes use of the resources upon which the tribal members rely in their treaties. Game, fish, medicines, traditional uses of these areas. The other thing that tribes look to in these types of enforcement actions is to protect historic properties, as I mentioned earlier. These are areas in which the Yakima and other Indian tribes have interests in preserving historic resources in those areas, even outside the reservation, within the nuclear sites, traditional cultural properties and other sites. And the ARAR would be the National Historic Preservation Act, looking to preserve those. And we run into problems with NHPA because the NHPA looks to preserve those areas, but at the same time, if you're doing cleanup, you may have to remove those resources. So if you're looking at contaminated historical resources, it's a very difficult question to run across for regulators and tribes to try and reconcile CERCLA and NHPA requirements. But I do want to emphasize that the Yakima Nation and other Indian tribes do have a role to play in the response side of things. And to finish off, I want to point out that tribes have an enormous interest in the ecological risk assessments and take a lot of the data that's used in the ecological risk assessments and tries to at least convert a lot of that into injury assessments for natural resource damages as well. So tribes can use the response process, the risk assessments, as a way to a sort of a gateway for assessments of injury to natural resources under NRDA as well. So that this is the types of roles that Indian tribes can play in cleanups at the nuclear weapons complex.
Great, thanks, Tom. Really appreciate it. So we are open for audience Q&A. We don't have any current questions, but if people want to chat them in or send them in via the Q&A, that works. And while we're waiting for people, I have a bunch of questions that I can throw to panelists to get us started. So the first one would be something that, Dan, you mentioned during your part of the presentation about contaminants that don't really have a federal standard or regulation yet, such as PFAS, which is top of a lot of people's minds, obviously, currently. So maybe if someone could talk a little bit more about how exactly those types of contaminants, I guess we could call them emerging contaminants, would get addressed under these regulatory frameworks. And is that a gap, or how exactly does that work? Is there more you can share around that? And I'll throw it to anyone on the panel.
Well, they need to be, you need to have a rulemaking to add them to one or more of the statutes we've been talking about, or perhaps the Clean Water Act, create some standards around them. In Colorado, we've listed a couple of the PFAS chemicals as hazardous constituents, which means if they are found at a site that is already subject to corrective action, we can require their cleanup. Our Water Quality Commission has established numerical standards for several of the PFAS chemicals kind of we have a narrative standard that says you can't have pollutants in toxic amounts in our waters. And so they've used the science out there around these PFAS chemicals to establish what numerical levels correspond to that. Some other states have taken similar action, and I know EPA is, I think, just published a notice of proposed rulemaking yesterday to add some of the PFAS chemicals to, I think it's safe consideration for listing under the Safe Drinking Water Act.
Great, thanks, Dan. Okay. Follow-up question I had was related to environmental justice. So I know the Biden administration is putting an additional emphasis around environmental justice, and not being as familiar with CERCLA, Rickra, AEA as you all, I believe there is an EJ component to those. So my question is, do you see, and this is a bit of a crystal ball question, do you see any impact on the administration's emphasis on EJ affecting the regulatory regime, regulatory frameworks?
This is Stephen Stout from Tennessee. I'm not sure that I see the impact yet, but I will say that there have been reports in the press that I can confirm that the administrator's decision that I was talking about earlier, that was issued at the end of December of last year, is under review by EPA under several executive orders, including the one about environmental justice. And I don't know how that will play out, but that's been reported in the media. I can confirm that that is true. And the other thing that I will say is the community that is nearby the landfill that has a majority minority population is an area that we were looking at environmental justice several decades ago, because it was downwind of an old incinerator that used to operate in Oak Ridge. So the emphasis in environmental justice in this administration is new, but it's not that environmental justice hasn't been around for decades. So, you know, it's not necessarily a new thing for us, but it may be an interesting new application of it, and it just remains to be seen.
Andy, I want to emphasize that the Yakama Nation and probably most other Indian tribes who have a connection to the nuclear complex are pretty excited about the Biden's emphasis on environmental justice because we have been pushing that issue at these sites for a very long time. This is a classic example of how environmental justice problems arise in this country. When these nuclear sites were founded, the Indian tribes in the area were not consulted about it. It is a disproportionate impact on their resources. They have never been compensated for the loss of those resources or the uses of those lands. This is a classic example of environmental justice problems. And so we are pretty excited about any emphasis that this issue will have in the Biden administration. And we're looking forward to discussing it with the Secretary of Energy.
All right, thank you, Tom. Okay, audience, feel free to join in, but I will just keep rolling through my questions until you do. So one question I had, again, Dan, you mentioned this during your part of the presentation, but it's the Defense Nuclear Facility Safety Board role. I think I've heard it referred to sometimes as a unofficial fourth or fifth or whatever you want to say regulator. Can you talk a little bit more about that?
Right. It's been a long time since I really thought about the DNFSB. They are not they don't have actual regulatory authority over DOE, but certainly have the authority to do some investigation into nuclear safety practices within the weapons complex. And in our agreement, I believe we integrated them into the decontamination decommissioning as part of the cleanup, which was, taking down the buildings. They were involved in a consultative manner in developing those plans, so reviewing and commenting on proposals. There was an MOU that I believe was just between DNFSB and DOE. That was part of the agreement. We can put that in the materials, I think, at the end of the conference.
Great. Caroline, you talked about some recent court decisions. I think the most recent one you mentioned was a 2019 decision. And it seems like the way the regulatory framework evolves is through a lot of times through those decisions. Are there any sort of pending or upcoming court decisions that would impact the framework that you're tracking right now?
That's a good question. Not that would necessarily impact the framework for the complex as a whole. There is pending litigation in Washington here over a penalty that Ecology assessed over violations of the tri-party agreement's requirements related to electronic data access. And there are arguments being raised there that, for example, that the TPA is mostly a CERCLA federal facility agreement and can't be used to assess penalties from the state, and some other kind of, I think this permit exemption may have come up in that case as well. But I don't think that will have broad impacts for the complex as a whole. It may have impacts for how the tri-party agreement itself is interpreted. So it's both a Rickra consent order, a federal facility agreement under CERCLA, and what we like to call a get-along agreement, just kind of the contract aspect of it. And we also like to say that it only works if the parties get along. And it works really well, I think, when the parties get along, but it doesn't work well at all when they don't.
Got it. Thank you. Okay, I know we are right up against our time limit here, so I have a lot more questions, but I think we're going to need to wrap it up. I just wanted to say thank you to all our participants on the call today. Thank you to all our panelists. Thank you to Mark, Steve, Dan, Caroline, and Tom for taking the time. It was all very informative. Again, this will be posted on the NJA website. We'll send an announcement around when that happens. And I also want to just thank National Association of Attorneys General and the National Governors Association for sort of co-hosting, co-coordinating this, our final webinar in the series. So thank you again to everyone, and we'll keep our fingers crossed that we'll see a lot of you in Nashville this fall.